Justice Lemons, do you have a view on this sort of critique that commentators often make?
Well, I think one of the dilemmas is defining what legislate means. I agree with Justice Mims that we all come to the issue with the idea that the legislature has certain prerogatives that are theirs. Similarly, we have certain areas of our expertise and our duties that are ours. And the question of what legislation means is often in the eyes and the mouth of the beholder. Someone told me one time is that whenever somebody doesn't really like a decision of our court, they will use the word legislate to describe it. But the dilemma is that you can't actually pass statutes that anticipate every set of circumstances that might be affected by it or controlled by it. And so often we are called to what I will call interpolate. We have to look at a statute, we have to determine what it clearly covers, what it by implication covers. We simply can't turn away the litigants and say, come back someday in the future when the legislature has actually decided this question. We have to decide it. And I don't think that any reasonable definition of legislate includes those kinds of cases, because that's part of our duty. It's part of what we do. It's our oath of office. But from time to time, there are courts, as Justice Mims has said, that have a much more active view of their role. And frankly, they tend to go beyond the boundaries that the legislature may have set in certain areas. And when they do, I think that's when they legislate. But as long as we're within the boundaries and we interpolate, what we're doing is what we're called upon to do. It's consistent with our oath.
Let's talk a little bit about the court's engagement with the public. So some members of the public might have a very good sense of what the court does and what the court does in the regard that we've just been talking about. And some might have a misunderstanding of what the court does, which may lead to some of the comments that we've been discussing in the abstract. Justice Lemons, I'm wondering if you could talk a little bit about what aspects of the court's operations or what the court does do you wish perhaps the public knew more about?
I remember one time being approached by a woman that I have known for many, many years in a public place. And she said, I want to lobby you on the such and such a case. It was a case that was pending on our docket and was receiving a lot of attention in the press. And I said, you can't lobby a judge. And she said, why not? You're a public official. And I think at the heart of some of the things that the public, just generally speaking, just does not understand, is that we have an entirely different role and an entirely different purpose as a public official than their elected public officials do. We don't get lobbied. And I think they tend to, on many occasions, interpret what we do in the same way that they interpret what the elected branches do. They interpret it politically. And I know that I speak for my colleagues when I say there are many things that I have encountered as a judge that had I been in the legislature, I would not have crafted it in the manner in which they have done, and I wouldn't have supported it. But it's not my role to do that sort of policy. As long as it's constitutional, it's their role, the legislature's role, to do that sort of thing. The public doesn't understand that, most of the public. And when they see a decision that we make, they're more often than not going to interpret it through political lenses. That's not how we do our job. I would say one other thing about that is that an appellate court generally has matters before it that come in two categories. One is error correction, and the other is what we would call law development. Most of our cases are error correction cases. And as such, they don't involve the kinds of things that you've been asking about. Is this legislation? Are you beyond the boundaries? Generally speaking, most of our cases involve boundaries that are fairly well set. The question is, were they followed in the court below? And those are error correcting cases. It's only in what we would call the law development cases that you get the kind of issues that you've been asking about.
But even in some error-correcting cases, there's a question of interpretation. Does this term mean X or Y?
Well, there may be. When we have cases like, for example, sufficiency of the evidence cases, it's rarely that. Those kinds of cases, we're reviewing the record and determining whether a particular party bore their burden. And if we decide that they didn't, we say so. And there's nothing controversial, I think, about that. There's nothing law development about that. It's simply error correcting. And a lot of our cases fall into that category. For many years, I've actually been involved in an orientation program with new judges in the Commonwealth. And whenever I have general district and juvenile and domestic relations court judges, I always tell them, I said, you may not be the court of last resort, but you are the court of lasting impression, because that's where the citizens of the Commonwealth see the judiciary. A judge whom I know, who will remain anonymous, has a speech that he gives, and it's entitled, Why I Hate Judge Judy. And the reason, it's a very entertaining speech, but he gives this speech because the knowledge of the judicial system for most people has come from sources that are at best misleading. And so, as my colleagues have said, there's an enormous amount of misunderstanding about the court system. Some of them is simply because they haven't seen anything, and some of it is because they've seen the wrong things.
This is the CSI effect that prosecutors often complain about with juries. So is there a way, do you think, to make the workings of the court even more transparent for the public?
Well, you know what's fascinating to me is I have people come up to me all the time and ask whether or not they can actually come to court and watch. And you would have thought that that was such a bedrock fundamental principle of democracy that you wouldn't get a question like that. Frankly, I think we do our best to keep our proceedings open to the public. They come in, they watch. Recently, the Chief Justice, with our blessing as a court, put the transcripts or the oral arguments of the court on the website, so everybody who wanted to hear what the lawyers had to say and what our questions were can hear them. Other than inviting them to our table to discuss the case, which we are not going to do, I'm not sure what else we could do. All of us are publicly involved. We're out talking to community groups. Every single person on this court is out in the community doing the best we can to explain the role of the judiciary. I'm quite sure that a lot of time is spent doing it. I'm not sure what else we could do.
So let me ask perhaps a provocative question. Cameras in the courtroom? Is that a way to increase the public engagement, Justice Owens?
Well, we do have rules that allow that. At the moment, they are focused on the discretion of a trial judge. In the Supreme Court of Virginia, if you want to come in with a camera and you're in the media, you can come in. I mean, there's a way to request. We have cameras that have been set up. We've had arguments, at least snippets of arguments, on the nightly news. So we actually have allowed cameras in our courtroom. Whether or not you have cameras at the trial level is another matter altogether, and there's a lot of other issues that have to be addressed about that. You know, Justice Millett was talking about the juries. The jury is the most democratic element in the least democratic branch. And so when you have a reduction in jury trials nationwide, which we do, all of a sudden you have fewer and fewer people actually participating in decision making in the judicial branch of government. And I've always been of the opinion that our citizens trust the things they participate in, and they lose trust in the things they don't participate in. And as a result, I think the declining jury trial and the lack of participation takes away all the things that Justice Millett was talking about that were valuable about educating the public. And it's something we need to be concerned about for the future.
So let me invite anyone else to weigh in actually on that question. Are there other areas that?
I think there's a misunderstanding about how law development takes place in the courts versus the legislature. The legislature has an area of law that they want to address. They have the opportunity to address it soup to nuts if that's what they want to do. They have a holistic way of coming about a problem and addressing it. Courts are not like that, and they shouldn't be like that. It's like Justice Millett said. Justice, we spent so much time together.
We've said this for years, and he still can't get my name right.
He's Lee to me, and calling him Justice Millett is odd for me. But in any event, you hear this phrase, judicial restraint, and you ask yourself, well, what is judicial restraint? Well, I mean, it's like saying there's weather outside. Of course there's weather outside. What kind of weather do you think is outside? So there's a lot of different views as to what a judicial restraint is about. But at least mine, and I know some of my colleagues share, is that we have a minimalist approach to law development. As Justice Millett said, we only decide the issues that are actually presented to us. And when they are presented to us, most of us have a hierarchical way of deciding them. We don't address huge policy questions or constitutional questions if you can resolve it on a statutory issue. We don't address statutory questions if we can resolve it on the facts. And there's a hierarchical way of coming to a resolution of a problem that shows deference to a legislative body that's closer to people and to votes and to the population's view of things. So minimalism is a part of judicial restraint, and as Justice Millett said, we decide the matters that are before us mostly on the narrowest grounds possible. So in order to develop the law, it develops minimally. It's not that we don't get to it at some point in time, but it may take a while in a common law tradition for us to fully address the question like the legislature does.
So Justice Lemons, what's your view of amicus briefs?
You know, the word amicus means friend, and sometimes the party or the organization filing the brief is in fact your friend, and sometimes they're far more interested in their own underlying policy issues to be your friend. So sometimes amicus briefs really are not helpful to the specific issues that are before the court. They may very well be policy driven, whereas we're probably going to be driven by the narrow answering of individual assignments of error. Now, having said that, in the famous Grutter case in Michigan, when it got to the United States Supreme Court, it was an amicus brief that actually resolved the case. It was filed by the Joint Chiefs of Staff. And if you read the majority opinion in Grutter, you'll see that the amicus brief by the Joint Chiefs of Staff made it clear that they thought that nothing less than the security of the United States was necessary. It was necessary to have diversity in the officer corps in order to have chains of command that were going to be followed. And as a consequence, the amicus brief made the point that if you don't have diversity in professional education, you're not likely to have diversity in the United States military. If you read the opinion of the United States Supreme Court, you'll find an amicus brief made the difference. Now, sometimes that's the case here, but more often than not, it's not the case.
So it sounds like, along with what Chief Justice was saying, that in those cases where you're not simply engaging in error correction, but are helping to interpret the law, perhaps a perspective that you haven't heard from before that highlights the policy issues might be an important. So part of what is part of the record in each case is the opinion coming up from the lower court. Justice Lemons, let me ask you, do you assess the case in any particular way or in any particular posture depending on where the case is coming from?
I often avoid discovering which judge it came from in order to avoid that being an issue. It shouldn't be. The judge who decided the case below ought to be just a neutral factor. And we ought to decide the case based on what's been presented to us, irrespective of who made the call at the trial court.
Could it be helpful to you in some instances? So related to our earlier discussion about everyone brings some background, some life experience to the case. So if you knew, for example, that the judge below had extensive experience in law enforcement or other sorts of areas that might actually be helpful to framing the case, would that be information that would be interesting to you?
Well, it's interesting you'd frame it that way because it raises another issue that we have in appellate review on matters of sufficiency of the evidence, for example. I mean, our standard is plainly wrong or without evidence to support it. Now, does that mean that we would have made the same decision? No, it does not. What it means is, does the trial judge have before him or her sufficient evidence to support their decision? And I know I speak for my colleagues when I say that we have cases that come before us that we affirm that we would not have decided the same way in the court below. And I suspect that is a deference that's built into the system that we respect.
Does that deference change depending on the experience of the judge below or the characteristics of the judge below?
I think it is without regard to the experience of the judge below. I mean, if we look at a record and the record is sufficient to support the judgment is affirmed. And I don't think it necessarily is influenced by the fact that perhaps a judge was a prosecutor one time, or a judge was a public defender, or a judge was a plaintiff's lawyer, or a civil insurance defense lawyer. I just don't think that has much influence at all once it gets to us. But I do think that the trial court has a lot of leeway once it gets to us, no matter what.
Justice Lemons, what about you? Do you feel as if by the time of the conference you know what your colleagues are thinking about a case?
The initial conference,
Yeah.
you're talking about,
Justice
right?
Lemon is already
Yes.
nodding his head, but do you think, I mean, by
well,
the conference you know, or not, or you get surprised?
Most times the answer is yes. It's the ones where the answer is no that are most surprising, because from time to time you go around the table and you make your views known, and every once in a while you really are surprised by how a vote comes out. But underlying all of this is one principle that needs to be stated. The opinions of the court are the court's opinions. Now, an author has a challenge of writing an opinion that attracts a majority in order to have a court's opinion. And so even if we were not inclined to listen to other people, you have to be listening to other people in order to command a majority and to have an opinion that is the court's opinion. And the Chief Justice, I think, is absolutely right. There's nothing that more keenly focuses the mind than writing. And many times you go from a table where what you've been doing is talking about it, and then you go back to your chambers and you actually have to write it, and it's a different question altogether.
So what do you do when an opinion doesn't write?
Oh my goodness, I do exactly what all of my colleagues do. You know, when I came on the court, and Chief Justice Kinzer now was on the court at the same time, there was a tradition of not talking amongst the justices until you got to this opinion conference that she referred to as the baptism. And I suspect the reason why it was referred to it that way is because you had no idea what your colleagues were going to say. Today, we don't operate that way. We feel free to pick up the telephone and call each other, send each other emails, and discuss things. So when we actually get to that second opinion conference, the first one is on the day of the argument, the second one was when a draft is out there, most of us have heard from our colleagues, and we have a pretty good idea where the pressure points are. It's a much better way to produce a majority, or for that matter, a dissent.
Justice Lemons, can you speak about this from the side of the majority opinion? Because the same issues are there as well, that opinion is going to be read by a variety of different audiences and has to speak to all of those audiences. So how do you try to address that?
Well, let me start by making the observation that in Virginia, there's one group audience that should not be addressed, and that is some idea that we have constituents. Now, in states where judges are popularly elected, they have constituents, and you can see a stark difference in opinion writing in those states, because when they write opinions, they're often appealing to a constituent base that may or may not return them to the bench. We don't have that in Virginia, and I'm very grateful that we do not, because as Justice Powell says, without that, you can simply focus on the issues. In some of these other states where there's an election around the corner, I am quite sure, and I know for a fact because I've talked to them about it, that the way an opinion is drafted may very well have a whole lot to do with how quickly the ballot box is going to be opened. We don't have that problem. And so that's one group of people that we don't speak to. As far as the others, in many respects, we go back to whether this is a law correction, an error correction, or a law development case. If it's an error correction case, you're speaking to the parties, the trial judge, or the intermediate court below, and you pretty much are limited to those audiences because there's not a bigger audience. In the law development cases, you may very well be speaking to future justices on this court. You may be speaking to the Court of Appeals. You may be speaking to the legislature. Take a look at this. Perhaps you ought to weigh in. So there are different audiences, but I do think it varies case by case.
So do you adjust your writing style depending on the audience you intend to address? Do you adjust your writing style depending on the type of case it is, or do you feel like you have a pretty consistent style?
Well, style is the word that I find interesting there. I think in terms of organization and things of that nature, most of our opinions look pretty much alike as far as organization is concerned. We've developed this not by some sort of agreed upon form, it's just been habit. You know, we bring on the case and we summarize arguments and then we knock off the issues one after the other. I think Justice Mims has said it well. Our style has not been to be personally confrontative. And I think that style has carried over in many ways to other audiences. We're not confrontative with the Court of Appeals. We address issues. We're not confrontative with trial courts. We address issues. So if you talk about style, I think the style that we have is a style that has been very well described by my colleagues. We address the issues, it's not personal, and we decide cases in two categories, error correcting and law development, and you ought to be able to tell by looking at an opinion which category it's in.
Just
an opinion out there, and I will not identify it, that was written by Justice Millett, but it was handed down by me. And I suggest that you'd have a hard time figuring out that he was the author. Question that you'd hear at our table often, and it comes from each one of us, to each one of us. And the question is that necessary to this opinion? Because that's the sort of thing that makes a minimalist out of you, because you have the experience over time as, I wish I hadn't said that, and more importantly, it wasn't even necessary to the opinion. And after a while, we start asking each other those kinds of questions. Two things that every appellate lawyer ought to remember when they're standing at the podium. And one is they need to think like a judge, because they need to respond to us and our questions in a manner that is relating to an opinion, and more importantly, a majority opinion, as Justice Millett was talking about. As a result, they need to understand that this is their only opportunity to sit at our table. And if you're going to participate in the development of this opinion, this is your only opportunity to sit at the table. You better listen carefully to the other diners. And that's why this opinion, the questioning process is so important. I remember once on the Court of Appeals, this dynamic of the judges asking questions that really weren't to the lawyer, they were to the other judge at the other end of the bench, got so acute that this lawyer said at one point, if it'll help, I'll just sit down and let you all work this out. Now, I don't suggest doing that in the Court of Appeals or in our court, but having said it, what this lawyer was demonstrating is the lawyer really knew what was going on. And this lawyer knew that some of the questions that were being asked by one judge on one side may very well be either the majority or the minority view of this opinion. But they followed the questions and not necessarily their briefs or their planned oral argument. Every lawyer gives 3 oral arguments: the one they planned, the one they gave, and the one they wish they gave. And so you might as well come up there and be flexible and in a listening mode rather than a mode that says, I'm simply going to tell you everything I had planned to tell you. When you get there, you might better be saying things that the judges want to hear, because you need to think like a judge.
Justice Lemons, do you try to help counsel a little bit in that regard, or?
Oh, I think all of us try to help counsel. I hope I'm not wrong about this, but I think we're a very user-friendly court. And I think there are concessions that are held against counsel that are made at the trial court and come up and are visible in the record. But as far as making a mistake in your oral argument before us, I think we're a pretty user-friendly place.
Justice Lemons, maybe I can start with you. How would you describe your judicial philosophy? Or maybe another way of phrasing it is, how do you think your colleagues would describe it?
Well, hopefully they're pretty close to one another. Well, I suspect we will. I think that a judge should be restrained in how they resolve the matters that have been presented to them. And that requires you to be, in some respects, a minimalist. You don't decide questions that are not necessary. You decide only questions that are, and you do it as narrowly as possible. And you do it because you respect other branches of government. You do it because there are some issues that are better left to other branches of government. There are some issues that ought to be decided by the branch that's being elected by the people directly. So I think my colleagues would say that I am somewhat of a minimalist in the true common law tradition of incremental change in the law, modest writing, narrow writing. At least that's what I aspire to do.
Do you find that frustrating, the minimalist approach? You mentioned earlier as part of our discussion that there are some issues that simply aren't presented to the court, but that the court might welcome at some point hearing about, and that there are some issues that simply aren't for the court to decide, they're for the legislature, even though you personally might not have decided them the same way. So does that approach, do you ever find that sort of personally frustrating, that there are issues simply that aren't there for you to decide?
Well, there are some cases that I wish there were issues properly presented to us that we could reach. But you see, we're full circle now. Because if we're frustrated enough to go out and reach them, then we are legislating. We're beyond the boundaries of what has been properly presented to us. And as a result, we simply wait patiently and hope that in the future somebody will raise the question that many of us have been wanting to answer.
So looking back, let me maybe ask several of you to comment on this, to the first day that you took the bench, and maybe Justice Lemons, I'll start with you. What do you wish you'd known then?
Well, I was asked that question shortly after I came on the Supreme Court with a large audience, and someone said, well, what was your biggest surprise when you got there? And I said, well, I thought we were all going to gather together on Fridays at 5 with perhaps a glass of sherry and discuss Marbury versus Madison.
That didn't happen?
It has not happened, and it is not going to happen for all kinds of reasons. You know, my colleagues talk about the workload. It is extraordinary what we have to deal with. There was a time in Virginia, and I remember as a lawyer, where it would take 2.5 to 3 years to get a case through the Supreme Court. And that was not a good time. And the court had a great deal of introspection back then. I wasn't on the court at that time, but I know they did because I've talked with any number of them, and decided that we need to hand down our opinions as best we can during the court week that follows the court week in which it was argued. Now that makes us one of the fastest turnarounds in America. And like Justice Powell, I think that there are cases that simply cannot be decided properly on that schedule. The idea of turning them around quickly is a good idea. There's just some of them that don't fit that model. So I share the view that many of my colleagues have here, that I wish we had more time, and there's some cases that ought to have more time.
Do you feel as if the process should be changed so that you do have more time in some of these cases?
Well, I think actually that's what's happening now. We respect one another on decisions to carry a case over. And we have been carrying cases over more frequently in the last several years than before. I, for one, think that it hasn't done any damage to the institution. To not have done it would have done damage to our relationships and probably damage to the work product. So I'm not at all concerned about the fact that we have been carrying some of these cases over.